I really just want somebody who's going to aggressively fight for me in court. Is that too much to ask?
Filing an eviction should not be complicated. There's got to be an easier way.
Nothing frustrates me more than having to wait for my attorney to call me back. I need them now.
What I really need from my law firm is someone who can provide my staff training so we actually can stay out of trouble.
When you have property management problems, we have your solutions. This is the Zona Law Group podcast with the experienced attorneys from Zona Law.
Hi, I'm David Pickron, and welcome to the Zona Law Group podcast. I'm thankful today that one of the partners, Mark Zinman here, is with us today to really talk to us about such an important topic that we're going to introduce to you in a second. Mark, how are you doing today?
Great. Thanks for having me, David.
Awesome. I think we talked about making this podcast really like a first day training. Like a day one, you show this to somebody new in the industry because it's so relevant on day one.
Absolutely. I think people underestimate how important fair housing is in managing properties across the board, from the large management companies to the ones mom and pop shops. It is critical to the business, no different than the Landlord-Tenant Act is. Awesome.
So today we are going to be talking about fair housing. And Mark, I wanted to start out and for those that might have heard it for the first time or just as new in our industry, why is it even here? Why do we have it? Why does it come around, and why is it so important?
Sure. It's an excellent question, just because managers really just see it day in and day out, and they kind of forget the history of why we got to where we are. I mean, as you know, we have a horrible history of discrimination in our country. There's no way around it. It's just part of the history of the United States. And the way to address that is through numerous legislative pieces have been tried to fix little things. That's in employment, that's in where people have housing, obviously, which is where the Fair Housing Act came out of. And so really, as the civil rights movement came out of the 60s, the Fair Housing Act was a main part of that, and a really big part of that, actually. And so in 1968, there's a lot of movements in terms of civil rights. And what happened is actually, historically, not to bore you with the history of it, in April of 1968, Martin Luther King was assassinated.
Okay. 1
week later, the Fair Housing Act was signed into law by both the House, the Senate, and Lyndon Baines Johnson was the president at the time, and he signed it all within that 1 week. This is actually legislation that Martin Luther King had been trying to push for years. And the reason was, at that point, there was a black-white issue that we had going on in our country, and you had issues of steering, which was like taking people, putting them in certain areas, keeping whites and blacks separated, obviously. We've seen the movies, we've read the history books, and the Fair Housing Act was a means to kind of address that right off the bat. And so when it first came out in 1968, it was a black or white issue. And so they had a couple protected classes really just to address that right off the bat. And then it got amended later. Things kept being added. So the next one after the initial white-black civil rights issue was women's rights. Came out in 1974. Sex was added as a protected class. What's people also, again, I'm a history buff. I love this stuff. What people don't realize is women's rights, the women's suffrage movement has always tracked the civil rights movement. So it's gone through history in terms of first, race and color were added as a protected class, and then obviously 6 years later, sex was added as a protected class, and that was 74. And the final protected classes that were added, and we haven't seen any since, was in 1988. They added familial status, which obviously protects kids, anybody under the 18. That adds where you see occupancy standards and checks and applications, and also disability as a protected class. And disability is kind of where we are really now with terms of fair housing complaints. That is by far the number one complaint that we see. I think the statistics show about 60% of all HUD complaints that are filed fall under the disability. So as we've grown as a country and as things have changed over the years, it's really gone from the race issue, and it's really become much more, at least in fair housing terms, disability, which is what we see day to day now.
Gotcha. You know, I used to, back in the day, familial status I saw was, kind of not really quite understood in apartment communities, right? Where, hey, this is kind of the family side, and this is kind of the single side, and they were trying to put people in around their communities, and I really saw a lot of errors when it came to familial status. Do you see that anymore today much?
We don't see it as much, and I'm sympathetic to it. And what people don't realize, especially with familial statuses and any type of discrimination or fair housing, even if you're trying to help somebody, it's still discrimination. It's still wrong. So especially with me, I've got 2 young kids. I understand in an apartment community, I would want to be away so my kids don't disrupt everybody else on property. Look, my kids get up early. They start banging against walls. They make noise. We could get noise complaints.
Right.
I'd want to be around other families. But in the management world, you can't look at that. From management's perspective, it's up to the tenant. They get to pick where they want to live. You would never direct any type of person to a certain area. That's just not an issue as much with families anymore. What we're seeing still with familial status is really the occupancy issue, just to make sure that managers don't unreasonably restrict families living in properties.
Perfect. I've been to the real estate classes and to a ton of training, and I've sat through hours and hours of this, which I don't really think it's that difficult of a law. It's really not that difficult, is it?
No, the law itself is actually really not very long either. It's once it comes into the application and then you see this expanse of questions of how do you actually address all these issues, specifically disability. It just simply, the law says don't discriminate based on somebody being in a protected class such as disability. Well, manager can say, okay, I'm not going to discriminate. And then you're like, oh, wait, do I have to allow assistance animals?
Right.
Do I have to install a grab bar? What about a ramp? Or all these other nuances that aren't actually written into the law that suddenly, once you put it into the real world of managing, a 400-unit apartment community, you realize, oh, it's not as simple as the text is.
Right. So I'm a new employee on day one. Someone comes into the community, wants to see some models, right? How does this fair housing play? Is it more of a mindset? Is it the way I communicate? Tell me what should be going on through my head as someone comes through the door.
Sure. I think for the first thing for me, always with any manager on day one for management skills, I tell them, look, you're in the customer service world. You're selling a property, right? You want the applicant to come in. You want them to be excited. And your job, and most people that go into this are really good at customer service. What they have to realize, though, is that because of fair housing laws, they have to get out all the same information to everybody. And they kind of have to have a routine of the speech that they say to every single applicant that comes in the door of, these are the amenities we have. If something's important to you, go take a look around. Anybody that qualifies, we'll accept them. And it's really so important, especially for the larger operators, larger managers. A lot of those policies have been done ahead of time, like what they'll accept. Those things are critical for running a property well. And it's knowing ahead of time what those policies are. And then when you're interacting with the residents, just reiterating those policies over and over again to ensure that its consistency is critical.
So we're human beings. We're not robots. We can't absolutely just say the same words and do the same thing. We do need to have a mental mindset of we just need to treat everybody the same. But I think I heard you also say that if you give a tour, kind of give the tour the same way.
Correct.
Right? And follow through with your policies the same way with everybody, no matter who it is.
Yeah, exactly. Right? You're not a machine.
I mean, you really don't even have to know the protected classes if you just treat everybody the same.
Correct.
Right?
If you're giving out the same information, regardless of who comes in the door, that'll protect you from a majority of complaints. You have to realize where it came historically, kind of what you referenced earlier, is families. Right. Like if you give a tour and you saw a family, 2 young kids, you're like, oh, well, I'll take them to the playground.
Right.
Not even mentioning that it has a pool, and not even mentioning the gym, because you think you're targeting that for them.
Right.
Whereas the next person walks in, maybe it's a single guy that's 30, you're like, well, I'll show him the gym, I'll show him the pool.
Right.
That's a problem, is you're giving very different information about that same property to 2 different people.
Right. And where I think maybe you'll get caught is you'll have multiple people at a community at the same time, and they're all watching each other, and they're all comparing how they're treating you versus how they're treating me, right? And that's kind of where people start wondering, hey, am I getting a fair shake here? And would you agree?
Oh, there's no question. I think even a lot of the interactions that managers have with tenants across the board is maybe they just don't get along with each other.
Yeah.
But just because you may not like me, it's not going to be something I did. I'm honestly going to be like, well, there's a reason he's not being, treating me differently. And then they start looking for that reason. And that's where a lot of complaints come out of.
Perfect. Well, I think it is a simple act. I think that you treat everybody the same is a simple way to say it. But let's get into really what you say, the 60%, and that is the disability part of it. I mean, because now all of a sudden we're starting to ask for reasonable accommodations.
Yeah.
And will you explain what a reasonable accommodation is?
Sure. So under the Fair Housing Act, like it said, you can't discriminate against somebody that's in a protected class. The 7 protected classes are race, color, religion, national origin, sex, familial status, and disability. And over the years, disability has, like I said, become the most prominent complaint coming out of. No manager in their right mind is going to say, you know what, you're disabled, I'm going to discriminate against you.
Right. What
happens, though, is beyond just simply allowing somebody that's disabled into the property, you also have to grant reasonable accommodations and reasonable modifications. And they're big terms, but what they mean is close, but two different things. A reasonable accommodation is a change in the policy or procedure to allow the disabled person to reasonably use and enjoy the property. The most common of what we see with that, which is you have a no pet property, and they say, you know what, I have an assistance animal, therefore we need to waive the no pet policy and allow me to have the assistance animal. On the other hand, you have what's called a reasonable modification, and that's a physical change to the structure of the building to, again, allow the person to reasonably enjoy the property.
You know, Mark, I've always wondered, why do I go to a hotel and I see they have this disability armchair that goes down into the pool water, and then I go around to apartment communities and I don't see that? What makes a hotel have certain accommodations and apartments?
Well, it's an excellent observation. To be honest with you, I think most people don't even think about the differences there, but they're huge from a legal perspective. And the reason is because different laws apply.
Okay.
When you're in a hotel, you're dealing with what's called a public accommodation. That's anywhere that John Doe off the street can walk in, go, he's paying whatever the nightly rent is for that hotel, and they get to use all of the amenities are on the hotel. So it's meant for the public.
Okay.
That's under the Americans with Disabilities Act. So that's an ADA law for public accommodations. On the other hand, what we have in the multifamily world or in the single family world, just the rental world, is the Fair Housing Act. And so the laws are different. Now, what's important about that is on a multifamily property, there are certain areas that are for the public, but everything entirely is for the Fair Housing Act. So if you think about it, where on a apartment do you think you would want John Doe off the street to go?
To the office.
There you go. Right off the office. And everybody else says, okay, well, the office, probably the walkways, the pool, but not really.
Right.
Your walkways, the residences, and the pool, those are for your residents and their guests. The office is where you'd want somebody to come to because that's how you actually get your next residents to come in. So that has ADA requirements. That complies. That's also a reason that a lot of apartment communities, for example, have the parking out front that says future resident parking. That shows this is ADA parking, and then they have this like invisible line behind it that's the resident parking.
Gotcha.
So the resident parking is fair housing. The parking out front is the ADA parking, and there's different requirements. So going back to your question, like a hotel will have the chairlift because that ADA requires the chairlift.
Right.
Apartments don't have that same requirement. And the flip side that people don't realize as well, apartments will have pools everybody has to use. Whereas hotels, they don't have familial status discrimination, so they can have an adult pool where the adults can have their beverages and not have kids running around, and then they can have a kiddie pool where the kids sit in, 2 feet of water.
Right.
You'll never see that in an apartment community.
Gotcha. All right. Well, so I imagine we walk in to look at a place. We're under ADA at that point, so the bathrooms are going to have maybe rails in them, and we're going to kind of ADA, American Disabilities Act rules in the office.
Absolutely.
And then outside, fair housing. So love that.
Correct.
I love that distinction.
And an important thing to know there, too, because it applies outside, and people, our listeners here have probably seen it all over the city. If you ever go into like a restaurant or maybe a certain shops, like a smaller shop, and you go in and you're like, oh, well, can I use your bathroom? And they say, no, we don't have a bathroom. And you can literally see the bathroom behind them. But they say, nope, that's just for employees. And the reason is that's not an ADA bathroom. It doesn't have the grab bar like you mentioned. And so they can't allow the public in there because if they did, they'd get sued. So they make a bathroom just for the employees.
Okay, can I move on to these emotional support animals? Because these seem to be a big part of this, and these seem to be getting a lot of people in trouble. I mean, I'm on an airplane the other day, and I've got this little pooch sitting next to me coming out of a purse. It's like sniffing on me, right? I know we're not talking about, apartment communities right now, but, it's their emotional support animal, and they have to have it, and it's allowed to be on the airplane next to me. And I'm a dog lover. I have dogs.
Absolutely.
And I actually have therapy dogs that actually go to hospitals, and so I'm not a dog hater at all. But can we really talk about how can you tell whether someone really has a disability? Can you ask them if they have a disability? And how do you know if the animal qualifies for this?
And it is one of the hardest things that we see right now in this area of the law. It's just complex, it's nuanced, and frankly, HUD came out with an opinion this week. It's just ever-changing is the reality of it. What you have, though, is kind of going back to the ADA. You have really 3 different issues where it usually comes up. Public accommodations, which is the ADA.
Okay.
The airlines have their own set of laws, like you're mentioning on the planes. And then we have fair housing, which also allows assistance animals. Generally, in the assistance animals, in the fair housing world, if the person's disabled and needs that animal for the reasonable use and enjoyment of the property, they're going to get it, which sounds like two easy questions. But what that is, it opens a slew of other issues that can come. You talk about what kind of animals, what kind of disabilities. The way it usually comes up is, let's say, person brings their dog in, right? They list on their application, they've got no dog. 3 months in, the manager says, hey, you've got a pet in the property. What does the manager do? Well, here in Arizona, it's a non-compliance. It's generally just a breach of the lease. They have an unauthorized pet. You serve them a 10-day notice. They then immediately come in and say, oh, this is my assistance animal, or oh, it's my support animal, or it's a service animal. Always then the manager hopefully calls their attorney or knows this stuff and says, okay, we're now going from just you breaching your lease over into the fair housing, the reasonable accommodation, how we handle assistance animals. And so for purposes of fair housing, you need confirmation that the person is disabled, and you need the confirmation that they need that animal for the reasonable use and enjoy that property. What people get really, really confused on is assistance animal is a very, very broad term. That can mean almost any type of animal. You have the domestic ones, right? Cats, dogs, maybe a rabbit, turtle often, but even more unique terms as well is like monkeys, potentially, miniature horses, all of these other kind of things. And if they provide something for that person, now that can be emotional support, that could be physical support. All of those is that huge bubble of assistance animals. People always think just service animals, but service animals are one little part of that.
Well, they're kind of rare because I can almost see why you need a service animal, right?
Like a seeing eye dog.
Like a seeing eye dog or someone. And usually when they would come into the office, they'll be with them most of the time because they're, not all the time, but most of the time. It's the one that you're talking about where, no, I don't have a pet. And then we do have a pet 3 months later that I think we get in a lot of trouble.
Yeah, correct. And it's where we see it the most that causes the most confusion for managers, where you have like somebody with PTSD, anxiety, and depression. Those are the kind of three that I see the most in terms of requesting an accommodation to have the emotional support animal, the assistance animal that you're not able to just see with your eyes. Right. So the way the Fair Housing Act works is if you see it with your eyes and you know that person's disabled and they need it, you're not allowed to ask for any other documentation. Okay. So if somebody comes in, they apply, they've got a seeing eye dog, it's obvious they're disabled because they need that dog to be able to walk. It just, we're used to it as a society. Right? We're not as used to the emotional support animal that provides it for anxiety or PTSD. So if the person says, oh, no, I've got an emotional issue, I need the animal for that, you're allowed to ask for medical verification that, yes, they are disabled and they need that animal for that disability.
What wouldn't we ask?
The one question kind of the never cross this line is what the nature or extent of the disability is.
So we never say, what is your disability?
Yeah.
We just say, are you disabled?
Correct. Once you say, tell me about your disability, that's a no-no. That's kind of the hands off.
Now, if they start offering it to you, oh, yes, I have this and that, do you have to say, no, stop, I don't want to hear about it? Or they're just offering the information, you're okay now just to roll with the conversation?
From our side, it's not even relevant to you, really.
Okay.
I mean, if they offer it, I guess you don't want to be rude and cut them off, but it's not really relevant for you.
Okay. Awesome. I just think when we can't charge pet fees, we can't charge pet rent, there is a big incentive for every animal out there, no matter whether you're disabled or not, to become a service or an emotional support animal. And that's why we're seeing a lot of this, is because I don't have to pay my extra $35. I don't have to pay my $200 pet deposit.
Well, that's actually created a market out there for websites that print, you pay $65 and you get a certificate and it says you are allowed to have this. Usually they use the term service animals, but some of them use assistance animals as well. Yeah. And the person knows they can go online, get a vest, get a badge, and then they don't have to pay pet rent. They don't have to pay pet fees. They don't have to pay a pet deposit. But what's important to know is that if somebody does have a valid assistance animal for the entire term of the lease, you don't charge any of those things. But if the animal causes damage and it's not returned in the proper condition, the tenant's still liable for that damage. You can charge them if the carpet's soiled, if the baseboards are eaten up, if there's scratch marks on the door. The tenant's liable for all of that. You just can't on the front side charge them deposits and fees for that.
Okay, I have someone come in with a service or emotional support animal, and it's pretty aggressive at me. It's growling, it's barking a lot. Is there any judgment I have there to say yes, no, or do I have to allow that animal?
So the first question always, before we even get to that, is I've got restricted breeds. I don't allow them, right? I don't want Rottweilers on my property. Person brings in a Rottweiler or pit bull. Do I have to accept it? The answer is yes. If it's an assistive animal, right off the bat, you're starting with, there's nothing wrong with this specific dog just because I have a conception about what restricted breeds are. You still have to allow that animal.
Okay.
Then the next question is, okay, what if that animal suddenly becomes aggressive with me? Then you can take steps to remove the dog or potentially not allow it. But the distinction there is with knowing general concepts of a pit bull, like, oh, I think all pit bulls are dangerous. That's not enough under the Fair Housing Act to reject one. But once that specific animal is dangerous or threats to other people, then you can take action. So where we see that a lot is people have assistance animals and they actually bite somebody else. And the managers are like, well, I can't do anything, right? That's their assistance animal. I say, no, you can still evict them because they've bitten somebody else. They're now a liability for the property, whereas that's different than just I don't like pit bulls.
Right. So just to clarify, I can have a breed restrictions if they're considered pets, but once they go into this fair housing rule, they are no longer really a pet. They're almost like a wheelchair in a way, right?
100%.
And they're no longer a pit bull. They're almost like a wheelchair.
Exactly. That is truly my favorite analogy in terms of how you handle any kind of request, which makes sense why you would waive fees, why you would waive deposits. Somebody would never come into your office and say, oh, you're in a wheelchair. I'm going to charge you an extra $60 a month in rent. That's offensive right off the bat. People don't have that same mental hiccup, though, when they do it with assistance animals, but they should. Any question I always get from clients, and I'm getting, I don't know, probably 50 of these questions a week from clients.
Okay.
Always I default back to, okay, take a step back. If it was a wheelchair, what would you do? And then you go through that same process.
Makes it a lot easier.
Exactly. So if, like, again, going to that same analogy with the pit bull, well, the person has a wheelchair. Are you going to refuse them? No. But if they take the wheelchair and hurt somebody, are you going to have to remove them? Yes, because that's where the liability then comes in.
I think that is just great information. I certainly appreciate that. I want to kind of come back to maybe when somebody has lost their sight or just cannot hear and is deaf. And I want to talk specifically, what are your responsibilities as far as, obviously if you can't sign and you can't communicate with them, or how do you handle, let's go through a blind person first and then maybe a deaf person. And what are your responsibilities as a housing provider?
Sure. This has actually become more common in terms of lawsuits recently. There's a slew of them over the past couple of years on hearing as a basis for complaints regarding disability, where housing providers, apartments mostly, where they're getting calls, they're getting tested by different agencies, are getting calls from like a TTY line for somebody that's deaf, meaning the person's not able to use a regular phone. They use a phone that assists them or an interpreter that assists them as an interim. And usually what happens is the company will call in, manager picks up, and they'll say, hi, I'm calling from a TTY line on behalf of this applicant. And from a manager's perspective, that really shouldn't matter, right? But in this world, everybody's so used to spam calls coming in. In the past 2 years, managers have just hung up the phone thinking it's spam. So numerous lawsuits have popped up actually because they're not working with those disabled residents because they can't hear. They truly are discriminating against them just because they're deaf. The manager should always listen. Oh, it's a TTY line. Okay, they continue on the call. It doesn't affect the rest of the management of the property. It doesn't affect their day-to-day. It doesn't even affect the phone call. They just have to know to be aware of that because those lawsuits do exist and they're out there. And similarly with somebody that's blind, you may have to do certain different things for them as well, like modifications. They may need, going back to a deaf person as well, a doorbell difference. They may need to install a doorbell that flashes instead of a doorbell that dings because obviously they can't hear it, but one that just flashes in their unit. Oh, okay, somebody's at the door. It doesn't affect the management of the property. It doesn't even really affect the value of the property, and it really allows that deaf person to be able to use and enjoy the property, and that's the important language there.
Perfect. So if there's a blind person there and I have a lease form, are they required to bring somebody in to read the lease to them, or am I required to read the lease to them as the housing provider?
It always, obviously, we're talking the nuances of law here. In my opinion, always you would be better off reading that to them.
Okay.
Recording it, saying, hey, you've asked me to do this. I'm happy to do it, and then read the lease and go over it with them. And the reason is that we've talked about reasonable accommodations and reasonable modifications. Well, what does that actually mean? The term reasonable under the Fair Housing Act means that it's not a financial hardship, it's not an administrative hardship, and it doesn't change the nature of your building, the way you run your business. And so I think reading to a lease to a person is not unreasonable for somebody that's blind. I always suggest if they want somebody else to explain it to them, they have somebody else do it. But if they ask you to read something to them, like a 5-day notice, you should read it to them. That way they can reasonably use and enjoy the property just like anybody else would.
But I love you say record it, right? Because I could see someone saying, oh, when you read it to me.
There was no late fees.
I mean, yeah. How can you possibly take all of that information in and almost record it and almost give them a copy and say, here's your recorded copy of your lease? Would you recommend that?
I think it's a great idea. I think the recording is the best that keeps everybody above board. Like, oh, well, you didn't tell me my rent was $1,200. You said it was $600. Well, no, I didn't. But without the recording, you have no proof. And I think it's an important point here in terms of the big issue of fair housing here. And this is always the way I teach it. And I think it's critical for managers to understand. We're talking very nuanced areas, right now. I don't expect managers to know that on site, what the answer to that question is. If a manager says, oh, I don't know, do I read it or not? That's not a manager's job. A manager's job is just to recognize, I realize this is a fair housing issue. Let me talk to my corporate, let me talk to my attorney, and I'll get back to you. 100% of the time, that is an acceptable answer to tell an applicant, as long as you get back to them within a reasonable time. Like I mentioned earlier, HUD came out with an opinion this week, and theirs is saying a reasonable time may be up to 10 days to get back to a resident, depending on what the issue is. I'll tell you, for most clients that I have, we get back within 2 days.
Right.
Just in terms of most accommodations, managers do exactly that. I don't know the answer to that. I know we have a policy. Let me talk to my attorney and get back to you. They call me up and I say, okay, let's work through it. We give them the answer and then they can get back to the resident. And that works all the time. Where I see managers making mistakes, owners making mistakes, it's just not realizing it's a fair housing issue.
Right.
Maybe it's something they've never heard of, like multiple chemical sensitivity. And they're like,
what?
What is that? And they're like, well, that can't be real, so I don't have to do anything different. Right. Just recognize, yes, that sounds like a disability. We have a policy. I know we do. Let me talk to my corporate. Let me talk to my attorney and get back to you. And that helps tremendously.
Well, to jump back to just a real quick question on the service animal side, I'm sorry I didn't ask this, or the emotional support animal side, is we really are still qualifying or helping the applicant. It really has nothing to do with qualifying the dog or the cat or the emotional support animal. We're really, they're really just the wheelchair. We know what the wheelchair is. So we don't need to really worry about, is this a service dog? Is this a service dog? It's, do they need?
Correct. And that's where the biggest distinction is and where people get confused about like the online certificates that we mentioned before. Online certificates that are signed by like a chairman of a company that says this is a service animal or this is an assistance animal, most of the time isn't going to apply for fair housing. For fair housing purposes, the questions always are, is the person disabled and does the person need that animal to reasonably use and enjoy the property? Right. And so you really look, the focus isn't on what the animal does, it's a focus on what the person needs.
I think having therapy dogs, myself going to hospitals, we're always talking about qualifying the dog, qualifying the animal, and I think it's completely opposite in fair housing. We qualify the individual. So I just wanted to point that out. I know I jumped back a little bit, and I apologize.
It's a great point, because I think a lot of people get confused between service animals, which are just ADA, and then the bigger bubble, which is fair housing and assistance animals, which includes the service animals as well.
So, I've been in this industry for a long time, Mark, and, we want to help people. We want to provide good housing. We want to put in the flashing doorbell for them. We want to do things to help people. We're an industry really of helping people, because the bottom line is we want residents there for a long, long time. That's why we're in business, right?
Absolutely.
And so I would always just, when I first got into the industry and fair housing was this that got you in trouble, and fair housing came out, and then it was always a negative thing. But I think we really need to turn it around and say, listen, we're just helping people who need help.
I agree 100%. I think there's a negative connotation for some reason with fair housing. But again, if you look back to the history, it's for a good reason. We have these problems in our history. The statutes are created to fix specific problems. And yes, I know probably better than anybody else in the industry, there are abuses of the laws. I understand that. But you start with the fact that the law was written for a legitimate good purpose. We as housing providers need to be behind that. And that's why, specifically for me as well, I like teaching this stuff, because it's important. I'd rather a landlord understand it and really practice fair housing than make mistakes that they just aren't even aware of.
So let's wrap up this podcast and this training with this question. I'll let you kind of wrap it all up yourself. if I'm a housing provider and I just feel like someone's trying to pull the wool over my eyes, they're the ones that I think they're taking advantage of this, okay? And I'm suspect. What would you recommend I do?
Are you saying for like assistive animals, or we got?
I mean, almost anywhere. What should I do?
All right. Well, for me, always follow company policies, right?
Okay.
Uniformly, what you need to do is follow company policies. You don't want to prejudge anybody. Let's talk going back about the applicant coming in. Here's your big answer for you in terms of fair housing stuff, right? You have an applicant come in. You don't prejudge them. You don't assume what they want different than anybody else. You give them the same information out. You have company policies ahead of time that set forth what your standards are. You make sure they meet those standards. The question is, will you rent to me? I rent to anybody that qualifies. Get their information. Have every single person go through the application process. Have everyone pay the fee.
Right.
Whoever qualifies, that's who you're going to rent to. So you basically follow the policies, enforce the policies to anybody. And anytime that there's like a change, maybe somebody needs accommodation, maybe something's different. We see crazy stuff on properties. That's where you start making notes in the file saying, okay, this happened today. It's a little different than normal. And you just track it. And those three things together protect you from the majority of complaints. I mean, unfortunately, with the abuses like you're asking, you really have to see how it comes up. I mean, if for assistance animals, you can ask for verification. But ultimately, your job isn't to catch somebody in a lie. Your job is to keep your occupancy up, make sure that everybody on the property enjoys their stay on that property. And it's only until really you start having disturbances that it becomes an issue. And then you're going to have to figure out, okay, we have a problem. It's a breach of the lease. What steps do I need to take if they're breaching the lease?
Okay. And a lot of times that is just call the attorney.
I was going to save the pitch on that, but yes. I mean, anytime, once you're realizing up front that, oh, if you're doing a good enough job and realizing I've got a fair housing issue, that's where you want to contact your corporate office. That's where you want to contact the attorney and say, okay, where are we going to go from here?
Awesome. Well, FHA, ADA, it doesn't have to be complicated. It just has to almost become a way of life of just helping people, you know, in their disabilities or in their different protected classes. We're certainly grateful, Mark, for your insight on that. We appreciate you joining us here today at the Zona Law Group podcast. And until next time, keep on renting. Thank you.
Thank you.